case of Jim Hood versus State Department of Corrections through Chris Epps. Court calls as defendants Nathan Kern, David Gatlin, Charles Hooker, Anthony McCrae, and Joseph Osmond. Is plaintiff ready to proceed?
Yes, Your Honor.
Is the Department of Correction, Chris Epps, ready to proceed?
Yes, Your Honor.
Is the defendant Nathan Kern ready to proceed?
Yes, Your Honor. Tom Porter appearing on behalf of Nathan Kern, David Gatlin, Charles Hooker, and Anthony McCrae.
Counsel, I don't have anything that shows you represent them. Have you filed the proper papers with my court?
I have, Your Honor. I filed
with the court?
Yes, ma'am. Yes, Your Honor.
I don't have it. Clearly, who did you file it with?
On January 20th, I filed a special appearance for purposes of a motion to transfer and/or a motion to dismiss.
And where did you file it?
In the circuit clerk of Hinds County, Your Honor.
I don't have a copy, counsel.
I emailed copies to your court administrator of that motion, the special appearance motion. I also filed a motion to disqualify the Attorney General's office. I emailed that to your court administrator.
Counsel, that's not the way you serve the court, is by email, not to a court administrator. First of all, she's not here. That's the first problem. So may I have a copy of what you allegedly filed? Now, let me see, Mr. Kearns. I need to see Mr. Kearns. I only need the 4 defendants who are named defendants. I need the rest of you to vacate the bar, inside the bar, please. Is Mr. Kearns here? Thank you, Mr. Kearns. Mr. Gatlin. Thank you, Ms. Gatlin. Mr. Hooker. Mr. Hooker. Thank you. And Mr. Osmond. Mr. Osmond is not here. Thank you. I only need the parties. I've got you in with all sorts of notes. If you're not a party to this action, I need you outside of the bar. So, I have one attorney who indicated he's representing all 4. Yes, sir. Yes, sir. Do I need to repeat that again? Yep. I only need the attorneys representing the defendant. Hold on just a moment. Thank you. Let me have the paperwork. Can you tell me you were representing the 4 defendants?
Your Honor, I, along with Mr. Eric Lowry and Richard Phillips, are representing the 4 defendants, named defendants. Announced.
That the record so
My name is Charles Griffin with Public Records. I filed an amicus petition.
you filed with the court?
Yes, Your Honor.
Okay. Where I've not seen, no, sir.
And
And if it's amicus brief, I'll read that after the hearing.
thank you, Your Honor.
Is the state ready to proceed to Mr. Hood?
Yes, Your Honor.
I believe you provided some motion.
May it please the court?
Yes, ma'am.
As this court is aware, on January 10, 2012, prior to former Governor Henry Barbour leaving office, he pardoned approximately 200 individuals. With these pardons, he released these individuals from the consequences of their crimes. Of those crimes included murder, manslaughter, aggravated assault, sexual battery, and statutory rape. Now, with allowing them to be released from the consequences of their crimes, these individuals were then granted or reinstated the right to vote, the right to carry firearms. And in the case of those committing sexual crimes, even the right to not have to register as a sexual offender and be allowed to work among our children in our daycares and our schools.
And counsel, those were the arguments you made to the court last week. We are here today. I believe on last week you all indicated that you were not challenging those persons whose sentences had been suspended by the government, correct?
Are you referring to the commutations, Your Honor?
Yes, ma'am.
That is correct. We are not challenging the commutations. We are
Well,
only...
that's what we're here about today, so we can stay on task.
Yes, Your Honor. But because we are asking the court to actually extend that temporary restraining order that the court issued on January 10th, we thought it would be helpful to give the court more background information that we've learned since that January 11th hearing.
Let me be sure that we're all here on the same page. This is a hearing to determine whether there was compliance with the Constitution.
That is correct, Your Honor.
To be sure there was more than just 5 people that had full pardons, correct? And you're only dealing with the issue of pardon individuals.
That is correct, Your Honor. And today we are actually before the court on 10 of those individuals that were issued full
You
and
told me on 5, you have a motion to amend. The court is not granted that amendment at this time.
Yes, Your Honor.
So let's take it one at a time so the record is clear, but you before we vote on it.
Thank you, Your Honor. Yes.
The injunction was initially entered with reference to 5 individuals.
That's
And you have brought those 4 individuals, served them, and they are before the court with their term.
That is correct, Your Honor.
The 5th individual is not here.
The 5th individual we have been unable to locate the 5th individual.
And there was an order that that person was to be here. What do you mean you could not locate him?
His whereabouts were unknown.
And what did you do to find him?
We contacted the governor's office to determine whether or not they had a file with regard to his application for clemency, which should have included an application with the current address. However, when we contacted the governor's office, they were unable to produce such a file. We do have our investigator here that actually conducted the investigation to determine the whereabouts of Mr. Osmond. If the court would like to hear from him, we'd be happy to provide that testimony.
What's the status of that person? Is there a warrant out for his arrest?
Not at this point, Your Honor.
The court will consider his contempt of court if an individual does not comply with the order of the court requiring him to be present. And so that has some concern. And of course, the first thing we have to do is serve the individual, and he has not been made available for service. Is that correct?
That is correct, Your Honor.
With reference to the 5 persons that the injunction was initially placed in terms of further stays, you had asked that you would amend the complaint at some subsequent time. I understand that motion was before the court.
Yes, Your Honor.
And tell me what you found with reference to the 4 that the injunction applies to who are already named.
Okay, Your Honor, we would take those one by one if that's okay with the
That
court.
would be fine.
Your Honor, we would first provide information to the court with regard to Mr. David Gatlin. Now, approach, Your Honor.
Yes, ma'am.
Your Honor, that is a certified copy of the executive order which granted the pardon at issue with regard to Mr. David Gatlin. The court will know that that is executive order 1070. We would ask that that document be admitted into evidence.
It will be marked at this time as claims 1. Any objection?
Yes, Your Honor, we do object to that document. It's not being presented by any witness. we're being denied the right introduction of this document to evidence this time denies us our right to due process and to confront witnesses against us. So we think,
Are you challenging the authenticity of the pardon?
I've just been handed this, so I can't tell you that. Yeah, I have to look at it.
We have a few moments. I just said we will take this and read a bail of your form and pass this to the mom. Yes, sir.
Judge, with the legal court, before I address this particular issue, I had filed a special appearance for purposes of motion to transfer and or dismiss the complaint filed by the Attorney General's office. If I may, I'd like to ask the court to consider and rule on that portion of that special appearance motion, which asks the court to reassign this case back to Judge Wheel. My understanding is that the case was originally by random selection in the circuit clerk's office when the Attorney General's office filed this, assigned to Judge Wheel, and for, I guess, emergency purposes, it was brought to Your Honor for ruling on the emergency TRO.
What did the order say? The reassignment order.
The reassignment order, as I recall reading, the judge said that you and Judge Wheel had discussed this matter and you were reassigning the case to Your Honor.
Then the motion that you filed was denied.
Thank you, Judge.
Yes, sir.
Now, I
I'm
guess
not going to hear your motions until I've heard what the court reported. Thank you.
with reference to this exhibit they're attempting to offer into evidence, I'm not unclear whether they're moving forward on the preliminary injunction or whether they're moving forward on a motion asking you to extend the TRO. Because I think my objection would be different depending on what type of hearing we're having right now. And I'm not clear on that. So I've asked for clarification.
Your Honor, it's the position of the Attorney General that we'll request an extension, a 10-day extension of TRO pursuant to Rule 65.
And then you're not going to deal with the 4 individuals that you have in court today?
Yes, Your Honor. In support of our request for an extension, we will address the circumstances surrounding those 4 individuals.
Well, I'd like to hear why you in my court today.
Yes, Your Honor.
Then I'll deal with your motions. I'll call your motions up and address them.
Thank you, Your Honor.
In which case, Your Honor, I would object to the introduction of this into evidence without a witness to properly authenticate it and without a witness to lay the proper foundation for the introduction of this exhibit into evidence. And that would be based on our due process rights and our right to confront the witness against us.
Yes. You object to the authenticity.
I object, Your Honor, I do not. I object to the hearsay.
And Your
Yes,
Honor,
ma'am, you may proceed.
thank you, Your Honor. We would respond by providing the court with case law that stands for the proposition of.
You may proceed with your case out if you have it.
Thank
I
you.
marked it as P.
Thank you, Your Honor.
I'm sorry. Thank you.
Yes, ma'am. Do you have all of 4?
We do have all 4, Your Honor.
It's not all 4.
Ladies and gentlemen, make sure those cell phones are off. Make sure those cell phones are off.
Your Honor, we have certified copies for all 4 individuals. I'm going to make that.
The copy to the defense counsel. All 5 of them will be sent to the court report and you mark them as P 1 through 5.
The next will be Executive Order number 1071 for Charles Booker.
That would be P2.
The next one, Your Honor, will be Executive Order number 1069 for Nathan Kern.
Judge, we would make the same objection as to P2, and we were making that same objection as to P3, that we made as to P1.
Yes, sir. Yes, sir.
The next one will be Executive Order number 1072 for Anthony McCray.
And we would make that same objection, Your Honor, due process and confrontation.
Yes, sir.
And hearsay. Thank you.
And the fifth one will be Executive Order number 1073 for Joseph Osmond.
And on those documents, we would just object to relevance as they refer to.
You represent Ms. Johnson?
I'm objecting on behalf of Mr. McCray, Kern, Booker.
To Mr. Osmond. You objecting on behalf of them to Mr. Osmond?
For relevancy purposes, it's not relevant to my clients.
Again, Your Honor, for the course of convenience, I'd like to take each one separately, going back to Mr. David Gatlin.
These are the pardons that you are challenging that were issued by the government.
That is correct, Your Honor. Those are certified copies of those pardons.
And these are the 5 pardons that you requested the court's injunction on last week.
That is correct, and we are now asking that the temporary restraining order be extended with regard to those 5.
I'll pass these back to the market for evidence. And what's the motion for amendment that you wish at this time?
The motion to amend, Your Honor, is to add those individuals that we referenced on January 11th that included the individuals that were pardoned that were currently incarcerated.
And you seek to amend, to add.
With regard to the motion, Your Honor, we seek to add Aaron Brown, Joshua L. Howard, and I'm going to spell this one, Your Honor.
Yes, ma'am.
Azikiwe, last name Kambule. Fourth individual, Catherine Robertson. Fifth individual, Kirby Glenn Tate. Now we will.
What's the basis for adding these individuals?
At the hearing on January 11th, Your Honor, these individuals were named as John Does, included in the John Does that were named under John Does, I believe, 1 through 203, I believe. We now have their identities and would like them to be specifically named. Even though they were included in the court's previous order, they were named as John Does. So we'd like to add them, naming them specifically.
you have the parties that you challenging?
Yes,
To those persons.
we do, Your Honor. We have certified copies of those pardons as well.
As to the allegations with reference to Roberson, Jones, Howard, I believe that's Campbell, and Tate, the court will allow the amendment to name Robertson in place of Doe 1, Jones in place of Doe 2, Howard in place of Doe 3, Campbell in place of Doe 4, and Tate in place of Doe 5.
Excuse me, yeah.
Your Honor, there are three of us that represent 5 of those named persons. We would object, they were not named as John Doe's 1 through 200 in the original TRO. If I'm not mistaken.
I haven't undone the amendment, so I don't know if you probably before the court at this time or not.
And again, I don't know what exactly the proper time would be, but that reference of John Doe's was to non-incarcerated individuals, which would not apply to our clients.
The objection is overruled, and that's with reference to what party you represent.
I represent Mr. Kamuli and Mr. Howard.
The rules provide for the court to allow the amendment. I note your objection with reference to your clients. I see 2 other individuals. With reference to what persons are you standing?
Your Honor, this is Edward Black, and I also represent Mr. Campbell.
And counsel.
I'm Sylvia Owen. I represent Curry Tate, but I also object because he was not included as one of the original 5 for parties number 1 to 200. The amended complaint clearly says
The objection is noted, and the court allows the amendment.
Excuse me, Your Honor, was Aaron Brown's name come also?
I don't have a Brown, no, sir.
Your Honor, Aaron Brown is included in our motion for amendment.
And then Mr. Brown will be included, and the answer to your question is yes.
Yes, Your Honor, I would interpose an objection on the same grounds as been previously stated for the other recently named
It will be
party.
noted.
And I represent Ms. Brown.
Thank you. The record is so indicated, and it will be noted.
The other day, with reference to Mr. Campbell, that's another grounds I'd like to state, that prior to the amendment, we had filed a petition for writ of habeas corpus in Yazoo, the Circuit Court of Yazoo County, and that the proper service in that case, and there's a hearing that's set on Thursday with reference to the petition for writ of habeas corpus in that case, and we would submit then that this court lacks jurisdiction in that we received our service filed prior to the court's granting, well, stated that it would grant the motion that was being made by the Attorney General's office this afternoon.
To which we would respond, Your Honor, the court's original order on January 11th included those individuals. Those individuals were already before this court under this court's ruling on January 11th. Therefore, this court had jurisdiction of those individuals first.
If I did, I would not have granted the amendment.
Thank you, Your Honor.
Your Honor, I would make the same objection that on behalf of Curry Tate that we have filed a motion in the Sunflower County for writ of habeas corpus with hearing that we set this week, and also challenging the court's jurisdiction on the TRO.
To which, Your Honor, we would have the same response.
Yes, ma'am.
Thank you.
Your Honor, if Ms. Robinson would do that, then we could reject that.
Ms. Robinson is included in that amendment, Your Honor.
First of all, let me make some preliminary remarks. The attorneys are standing in court with the assumption that they are properly before the court. Now, all of you know how to practice law, and I would expect that if we expect this court to listen to what you have to say. You talk through motions, and those motions have to be properly before the court. I am good, but I'm not so good for you to come the day of a hearing and start throwing motions in baskets the day before the hearing through emails. This hearing was conducted on the 9th of the month. We are now here on the 23rd, with everyone having an opportunity that if they wanted the court to consider their motions, they could have properly done so. I'm allowing the amendments to the original complaint that was filed by the Attorney General for the state. And during that hearing, it was the court's understanding that the other 200 or so individuals, some of which who had been released and others who had not been released, would be amended in a subsequent motion. The court will allow the amendments and now go to the motion of the Attorney General with a request for the extension for the preliminary hearing. The court has, by law, a requirement to set a hearing in 10 days. The court has set this hearing. I'd like to know the reason now the Attorney General is not ready to proceed forward in terms of preliminary injunction instead of a permanent injunction, but the case will have been heard on the merits. This is not a hearing on the merits of the case.
Yes, Your Honor, and to which we would present to the court, as the court just pointed out, since the court's ruling on January 11, we have been served with several motions on behalf of the 10 individuals that we now have before the court. We are asking for that extension, the extension of the TRO, so that we may have sufficient time to respond to those motions. We also understand that some of these individuals are just obtaining counsel, so we certainly want to respect their due process rights, but we would like to have sufficient opportunity, particularly to respond to all of the motions that have been raised. As the court has noted, we have been served this morning with a lot of these motions, a lot of them here at the table that we haven't even had a chance to digest. But these individuals still present a threat to the public. We would like to have the TRO extended another 30 days so that we may maintain the status quo. Thereafter, then set a hearing for the preliminary injunction, Your Honor. And I'd like to point out to the court that it is our plan to, at the point where the rules allow us to, we will be filing for summary judgment because we believe the facts are just that clear in this case.
In terms of your motion right now, the motion is for an extension. The court will grant an extension for an additional 10 days. The court will not say what happens after that 10 days, but it just means the Attorney General needs to do what he needs to do to get the information in the case ready for preliminary. The court issued a temporary restraining order based on what was presented. And this day, we should be here for preliminary injunction to make the determination if those individuals who were initially told to contact the Mississippi Department of Correction should be taken back into custody. As of this date, I take it that the Attorney General is not prepared to go forward based on the attorney's appearing and some motions. I will grant the extension to Monday is a difficult day because you disrupted the entire 4.5 days that we needed to be going forward.